Hello, welcome to this week's episode of the First Amendment on Trial. I'm Coco Casey, and my group mates Doug Cole Jr., Brianna Lewis, Alec Bacall, and Carter Conroy created a public relations firm in the social media and public relations class, where we're learning to develop a social media campaign. My group mate Alec Bacall created an animation for the opening graphic for our series, and the logo was created by another one of my classmates, Meredith Charles. These are amazing examples of experiential learning, or learning by doing, which is what RMU is all about. This is the third show in our four-part series of the First Amendment on Trial. We are live in the studio with students from Cornell High School, while we web stream to other schools from Weir, Propel, PA Cyber, so they can participate in this experience as well. Thanks for joining us. The First Amendment on Trial, freedom of speech, freedom of religion, was made possible by a grant from the Free Speech Center at Middle Tennessee State University. Professors Ann Sumerel-Jabro and David Jamison were awarded the grant for designing an inclusive learning experience, or learning by doing, that involves 3 academic units at Robert Morris University: communications, political science, and the Academic Media Center. We're all about intellectual experiences at RMU, and this one includes our audience too. Your job is to listen intently, determine which of the debaters researched and presented a compelling case to you to persuade that their argument was the best. At the conclusion of the debate, we'll all cast a vote for the most effective argument. Get ready, listen attentively, and cast your vote. Now to Professor David Jamison to introduce you to the debaters.
Thank you, Coco, and welcome to all of the audience for this segment of the First Amendment on Trial. Throughout this series of programs, we have an opportunity to explore some of the most important personal freedoms that we enjoy in our country, the freedoms guaranteed by the First Amendment to the Constitution: freedom of religion, freedom of speech, freedom of the press, and freedom of assembly and petition. To help us understand these freedoms, Robert Morris University criminal justice and political science students have researched significant cases from U.S. Supreme Court history. In these programs, you will hear our students present the arguments to the court in cases testing the First Amendment. As in a real Supreme Court appeal, each advocate will argue their client's position and will answer questions from the bench. Today's First Amendment topic is freedom of religion. The First Amendment guarantees freedom of religion in a variety of ways, but 2 important ones. First, that our government will never create a state church or an official American religion or favor one religion over others. And second, that we as Americans have the right to practice our religion as we choose. Today, 2 Robert Morris University student advocates will argue a case that asks whether a state legislature that sponsors a denominational prayer during its legislative assembly violates the Establishment of Religion Clause. Our advocates for this case are Jacob Toth and Celine Serenkoski. Jacob is a sophomore majoring in political science. Celine is a junior majoring in criminal justice. And representing the judiciary as our presiding judge is the Honorable John McCarthy. All rise.
Good afternoon. You may be seated. I will remind those in the gallery to please remain quiet during oral argument. I will now hear case number 19-313, Frank Marsh, petitioner, versus Ernest Chambers, respondent. Counsel, please enter your appearances.
Jacob Toth, representing Frank Marsh in the state of Nebraska, Your Honor.
Celine Serenkoski, representing Ernest Chambers, Your Honor.
Thank you. I will remind counsel that each of you will have 15 minutes for oral argument and 5 minutes for rebuttal. Mr. Toth, please proceed.
Thank you, Your Honor. To begin, I'd like to take a moment to speak about the facts and the history of this case. This case, titled Marsh v. Chambers, began in 1980. Ernest Chambers, a state senator in the state legislature of Nebraska, objected to the state's practice of having a paid chaplain come in and open each legislative session with a prayer. Senator Chambers sued the state, arguing that such a practice violated the Establishment Clause of the First Amendment. The case was seen before the District Court of Nebraska, which ruled that while the prayer itself was not unconstitutional, paying the chaplain was in fact a violation of the First Amendment. The state of Nebraska then sought an appeal to the Eighth Circuit Court of Appeals. Again, the Eighth Circuit Court found that the practice and the payment were unconstitutional in their nature. The state of Nebraska sought further appeal and requested certiorari from the Supreme Court. The Supreme Court granted certiorari in 1982, and arguments were heard in April of that year, and the decision was finally handed down in July. When considering the issue at hand, that being of state-sponsored chaplaincy, I ask that the court consider something that thus far the appellee has ignored: history. The history of the United States has been one dotted with significant religious influence. From the earliest days of the settlers at Plymouth, the religious nature of the American people has shaped our nation. By no means does historical fact necessarily justify the establishment of a state religion, but I contend that the actions of the Nebraska State Legislature do not constitute a violation of the Establishment Clause. Rather, Nebraska's actions are entirely consistent with the framework established by the Founding Fathers. This practice is one of historical custom and cultural preservation, and Nebraska is perfectly within their rights to continue the practice. From the very first days of our republic, religion and government have been in a very delicate balance. Some of the first European settlers of our nation, the Pilgrims, came here to escape religious intolerance at the hands of the Church of England. As our country grew and more religious minorities came to its shores, they would continue to define our nation. The end result has been a state of religious plurality, many different faiths, creeds, and beliefs living in relative harmony. The Founding Fathers recognized that such a diversity of faith did not weaken the country. In fact, it was a strength. That is undoubtedly why the framers sought to enshrine religious tolerance into the very framework of our nation, and why it is one of the very first freedoms guaranteed in the First Amendment. The Founding Fathers were deeply religious and spiritual men themselves, and of note is the fact that they also participated in the practice of opening each legislative session with a prayer. The Continental Congress, that legislative body that launched the revolution that birthed our nation, began its very first session with a prayer. That prayer, as is noted, furthered the revolutionary cause and emboldened their spirit. Even then, back in 1776, and as today, the state has a vested interest in the use of prayer in that manner. The Continental Congress's opening prayer was denominational and was performed in the Anglican tradition. However, this practice didn't serve just a spiritual purpose, but a secular purpose as well. According to a recollection of the event by John Adams, quote, "I must confess I never heard a better prayer, with such fervor, such ardor, earnestness, and pathos, and in a language so elegant and sublime for America and for the Congress. It has had an excellent effect upon everybody here." End quote. He later goes on to say, quote, "I never saw a greater effect upon an audience. It seemed as if heaven itself had ordained that that psalm be read on that morning." End quote. The prayer served to embolden the Continental Congress, raise their spirits, and further convince them of the justness of their cause. It did not provide just spiritual nourishment, but served a state interest as well. Now, almost 2.5 centuries after the Founding Fathers declared independence from Britain, the practice of state chaplaincy continues on. Because of our history, the practice has taken on a cultural value that the state has a vested interest in preserving. A shared history and shared values are two vital ingredients for building and maintaining a stable society, and every government is within its rights to pursue those two elements. Religious practices have historical significance in America. As previously mentioned, from the Pilgrims at Plymouth to the Continental Congress, religion has played a role in the creation of America. But even after we gained our independence from Britain, religion continued to serve as a guiding hand for our Founding Fathers. The very first session of the House of Representatives in 1789 opened with a prayer as well. That practice continues to this day, and throughout the years has carried on to numerous states and their governments as well. The issue that brings us here today is whether or not that practice is constitutional as practiced by the state of Nebraska. Nebraska has opened each legislative session with a prayer for well over a century now. Because of its long-standing history, it can be said that an opening prayer has become a form of historical and cultural preservation. In fact, that is what the state is arguing. This practice does not represent a breach of the Establishment Clause of the First Amendment because the effect on religion is marginal and because the practice holds cultural and historical significance to the state. Long-standing court precedent has held that state and religion can intermingle to an extent if it serves a valid secular purpose. For example, in Bradfield v. Roberts of 1899, the court held that the government can offer material benefits to certain religious groups so long as it serves a state interest and so long as it does not substantially benefit one religious group over the others. It can hardly be said that having a chaplain open legislative sessions with a prayer represents any substantial benefit to a religious group. At the time, the chaplain was paid a sum totaling $319.75 per month. In today's money, that equals about roughly $800 per month, and their legislative session isn't open all year. That sum is quite insignificant in the context of a state budget, and certainly not enough to substantially benefit one denomination over any other. Furthermore, as established, the preservation of history and culture is the concern of any government, be it local, state, or federal. In light of the historical context and past court precedent, it becomes clear that the First Amendment serves as a protection against firm, substantial religious bias. Incidental preference for certain religions, if in the pursuit of a vested state interest, and so long as said preference does not unduly burden or advance one religion or another, is permissible under the First Amendment. It would make little sense for the Founding Fathers to pen an amendment that would invalidate a practice that they had just participated in themselves. Thus far, the appellee has not shown that Nebraska's actions represent an undue religious preference. The state of Nebraska does recognize that mere historical precedent on its own does not justify the practice. However, the state contends that history, coupled with its vested interest in the preservation of its culture, and the relatively insignificant preference that paid chaplaincy represents, serves to justify the practice. Therefore, the court must consider this issue through the lens of culture and history. Failing to consider all aspects of this case would represent a grave misrepresentation of the facts at hand. When considering the totality of the case, there can only be one clear conclusion. The state of Nebraska is one intermingled with religion, and Nebraska's chaplaincy practices are simply a recognition of that history. The First Amendment is freedom of religion, not freedom from religious practices in their entirety. Nebraska is well within its rights to continue its practice. Thank you.
Counselor, your time is up. Ms. Sarankoski, please proceed for the response.
Thank you, Your Honor. May it please the court. The ruling on the case of Marsh v. Chambers carries a dramatic risk. This risk is a slippery slope to be observed when our nation further affirms an unconstitutional law almost solely on the basis of historical tradition. This law is not a mere precedent judicially arrived at, being scrutinized for constitutionality, but a policy decided by America's political elites and then manifested through the unconsenting citizenry's payment. Proof of this is provided by the case at hand and the fact that it had never initially been decided upon at all. My client, Ernest Chambers, has challenged the practice of the Nebraska state legislature in which he serves that pays, through taxpayer income, a Presbyterian chaplain to pray at the commencement of every legislative session. You heard that correctly. A governmental entity, an entity that is most subordinate to the wills of the Constitution, is siphoning money from Nebraskans to pay for a religious figure of one denomination under one larger faith to pray over their subsequent decisions. This ritual transparently violates the Establishment Clause of the First Amendment. Mr. Chambers himself is not a Presbyterian, as is the case for many in the Nebraskan legislature and the state's entire population. This practice does not, as the majority claims, tolerably acknowledge beliefs widely held among the people of this country, let alone the state. This practice is not representative of the Nebraska legislature, the Nebraska citizenry, nor the literal Constitution of the United States of America. I prove this on three different bases. 1, the Lemon test as established in Lemon v. Kurtzman. 2, the baselessness of historical precedent. And 3, precedents proving that practices such as these are not to be constitutionally tolerated. To begin, Lemon v. Kurtzman established a test to be applied by American courts on whether or not a law established a religion, a clear violation of the First Amendment. This test has 3 prongs: the fulfillment of a secular purpose, a primary effectiveness in that it does not advance nor infringe upon any religion, and 3, entanglement, the prognosis of how intrusive the government would have to act in order to uphold the prior 2 prongs of this test. The hiring of a paid Presbyterian chaplain to open state governmental hearings, as decided by the 8th Circuit Court of Appeals, fails all 3 prongs of this test. To begin, it need not be over-explained that compensating a religious figure to lead prayer in the Nebraska legislature does not fulfill a secular purpose. Secularism is void of religion, and the practice of speaking to and asking things of a higher power, as attributed to a sect of Christianity, is overtly unsecular. In terms of the primary effectiveness of Nebraska's policy, it indeed advances a particular religion, and arguably, by doing so, infringes upon every other religion for which an authoritative figure is not hired to lead prayer. As ruled in Engel v. Vitale, the institution of an official prayer in a public school is a futile attempt to include all faith is both disingenuous and against the law. As established in that case, even in the event that the public school's prayer involved aspects of each and every religion represented in said school and beyond, the act of prayer discriminates against the beliefs of those with no religion. Simply because the prayer practices aren't forced does not mean it is void of linking church and state. As in this case, the Nebraska legislature's prayer practices are a, quote, indirective coercive pressure upon religious minorities to conform to the prevailing officially approved religion. In regard to the Nebraska legislature, Presbyterian minister Robert Palmer has been staffed with the prayerful duty for 16 years consecutively. He is paid $319.75 per month to do this. All of Nebraska's taxpayers' money coming through that. This not only advances the exclusive cause of the Presbyterian denomination of Christianity by way of hiring only one chaplain to pray, but also by maintaining this chaplain without interruption or substitute for 16 years in a row. In the words of my side's dissent, this practice is an official seal of approval on one religious view. The aspect of officiality is rooted in the practice's setting, one that is governmental. The question over whether or not the legislators are literally forced to bow their heads is irrelevant. The incessantness of prayer and legislative hearings, every single one for over 100 years, and a 16-year marathon of one chaplain of one denomination is coercively subjecting legislators to a tradition they do not personally believe in. Engel v. Vitale also pays homage to the impossibility of avoiding judicial entanglement, as in order to ensure that all religions and no religions are represented, a condition that would adhere to the Establishment Clause, government would have to meticulously observe what denominations each chaplain hired belongs to, as well as how frequently and proportionately each chaplain is maintained or changed. As stated in Justice Douglas's opinion on Zorak v. Clausen, a case concerning students exiting of public schools to receive religious teaching, it is possible to not establish religion while sponsoring prayer, but it is in the context of including the opportunity for all religious influence in a given public setting. The students in Clausen were able to excuse themselves no matter their faith, and the privilege was not exclusive to Presbyterian children. We have established that to implement this in the Nebraska legislature would necessarily lead to entanglement, and as it stands, this freedom of religious diversity is not afforded to Nebraskan legislators. The present exclusivity of Nebraska's legislative chaplain awakens meticulous scrutiny, including whether or not the prayer is spontaneous, whether or not it insults those who believe prayer should not be undermined by being thrown into politics, even down to whether or not the prayer contains the term Christ. There are so many aspects potentially labeling this practice as exclusionary, whether doctrinally between Christian denominations or theologically as it pertains to the other faiths which are not Christianity. The opposition has based their justification for legislative prayer on historical longevity, as well as the supposed authority practices instituted at the federal level have. As this has been the practice for over 100 years in Nebraska, they say, it ought to be further upheld. We should reject this notion not only for the sake of common sense, but also for the aversion of a slippery slope that declares imperfection has a right to persist simply because it has for long enough already. Non-judicially arrived at precedent is arbitrary. Simply because a consensus-based tradition is arrived upon by mere originality does not make it worthy of continuation. Should this nation have persisted legislation in favor of slavery because it had always done so? I presume we all know the answer to this hypothetical question. Further back in time was the practice of appointing chaplains to the two houses of Congress. Why not allow chaplains in state houses then? Is the federal atmosphere not even more directly subordinate than the states? I will allow the words of President James Madison to answer these questions. Quote, "The Constitution of the U.S. forbids everything like an establishment of a national religion. The law appointing chaplains establishes a religious worship for the national representatives, elected by a majority of them, and these are to be paid out of the national taxes. Does this not involve the principle of a national establishment?" End quote. It is not out of line to demand that both federal and state governments adhere to the values of the Constitution. More than one concept can be wrong, and it is to be argued that it would be inconsistent not to demand that both of these formats be subject to the First Amendment. The majority seems to think the practices of federal authorities warrant a state's imitation. The concurring opinion details, quote, "The very courts in which this case was heard had religious influence in its opening proceedings. God save the United States in this honorable court." The judicial system, though, is not the be-all, end-all protocol for state entities. Are states now going to meticulously imitate the federal force's habits? That's surely neither an independence-based nor representative-based structure. The majority also attempts to bolster its argument with the fact that the opening of legislative prayer in Nebraska occurred before its statehood. Frankly, this point can be used as all the more reason to refine the state's policies, as the state itself has since been refined by virtue of becoming a state and not a mere agent of the federal beast. States ought to make their own decisions, and if anything, these decisions ought to be based off of the Constitution and not what the federal government does, incorrectly at that. If we truly desire to base our modern-day values off of historical values, this concept must be tested on both sides of the argument. So, I inquire upon the majority's response to John Jay and John Rutledge's objection to beginning the first session of the Continental Congress with prayer. According to the court, they, quote, "specifically grounded their objection on the fact that the delegates to the Congress were so divided in religious sentiments that they could not join in the same act of worship," end quote. This is precisely the issue we face in the Nebraska legislature. Worse yet, said issue is being paid for by taxpayers, the vast majority of whom are not even sitting within the walls of the State House. How detached are we willing to allow our representatives to be from the people they quite literally represent? The concurring opinion also asserts that Congress's authorization of appointing paid chaplains in 1789 occurred 3 days prior to the final agreement on the content of the Bill of Rights. What the other side does not understand is the possibility for our founding fathers to commit oblivious hypocrisy. Any attempt to validate the opinion with the claim no founding father would establish a practice violating their own Constitution is asinine. The Fifth Amendment seems to expressly prohibit slavery, yet it took our historical figures 8 more amendments to abolish this practice. By basing approval of legislative prayer on the first Congress's practices centuries back is conceptually betraying the very meaning of the Bill of Rights, protecting of states and individuals from excessive control. The Founding Fathers themselves are not sacred figures for whom we as a nation should collectively imitate in regards to their decisions during potential fits of religious passion. Rather, the document they made is the entity that we should reference. This is a document lorded over for 6 months by a collection of diverse minds, faiths, and attitudes. By listening to a mere man or group of men, we are treating flippantly a document meant to protect against the tyranny of these same men. As iterated initially, there are, unlike the policy of prayer in Nebraska's legislature, judicially, not historically, established precedents proving that overt establishments of religion in public and political life are unconstitutional. Epperson versus Arkansas established that the forbiddance of evolutionary lessons in governmentally funded schools is the officiation of Christian fundamentalism. The majority explains in quote that government may not be hostile to any religion or to the advocacy of no religion. By banning evolution-based education, it does this. It continues, quote, "The First Amendment mandates governmental neutrality between religion and between religion and non-religion. How then, I ask, would the active practice, maintenance, and publishing of a Christian concept, not just the forbiddance of another view, not be a violation of the Establishment Clause?" Everson versus Board of Education of the Township of Ewing ruled that a taxpayer should not have to fund transportation to a school with convictions he or she does not believe in. as the transporting of students to schools allows them to attend that particular school. Taxpayer-funded transportation is a coercive measure in advancing the religion inherently attached to the given school, in this case, Catholicism. The majority stated, to compel a man to furnish contributions of money for the propagation of religious opinions which he disbelieves is sinful and tyrannical. Even forcing him to support this or that teacher of his own religious persuasion is depriving him of the comfortable liberty of giving his contributions to the particular pastor whose morals he would make his pattern. No American should at any point feel alienated from his government because that government has declared or acted upon some official or authorized point of view on a matter of religion." End quote. This interferes with freedom of conscience, and it puts a monetary gun to the head of the citizenry. Torcasco versus Watkins struck down a Maryland law requiring a candidate to make a religious oath to run for office. I see many conceptual similarities between subjecting Nebraskan legislators to listening to a prayer they do not subscribe to, and Maryland politicians being legally obligated to continue as a legislator free from unnecessary conflict so long as they subject themselves to religion. The court declares, quote, "It is neither sacrilegious nor anti-religious to say that each separate government in this country should stay out of the business of writing or sanctioning official prayers and leave that purely religious function to the people themselves and to those the people choose to look to for religious guidance. The praying also forces citizens and legislators in Nebraska to make their religious convictions a public matter, and that if they decline to pay for or participate in prayer, this is visible." All of this taken into account, the concurring opinion of Marsh versus Chambers rests almost exclusively on historical longevity. Imagine if our nation was to attribute this argument to any controversial concept. Well, we've been doing it for long enough, so why change? America is a country which should be in constant pursuit of improvement. If we really want to appeal to history, allow me to guide us back to the Founding Fathers' conviction that the historical precedent of British rule must have changed. Imagine if they had remained complacent with England's dominance because it was how things had always been. This argument is preposterous and frankly dangerous. Thank you.
Thank you, Counselor. Before we get to our rebuttals, I'm going to ask a question of each of our counselors, and I will start with Ms. Sarenkoski. Ms. Sarenkoski, you suggest that some Nebraskans object to taxpayer funding for chaplains because they are paying for something that they themselves do not believe in. But my question to you is, doesn't this happen all the time anyway? What about the millions of anti-war American taxpayers who watched federal money flow to the 2003 invasion of Iraq or anti-war activists in the 1960s war with Vietnam? Does not this specific line of reasoning open up a Pandora's box by suggesting taxpayers can opt out of funding things they either don't believe in or believe to be wrong?
Thank you. So I would assert that there is a distinction between mere causes with potential moral or religious implications and the actual manifestation of faith, which is prayer. Prayer is a direct act that reflects religion, while causes such as war and interventionist versus isolationist policies can have religious implications but do not inherently the way prayer does. Furthermore, we have seen the Supreme Court uphold the right of private businesses to opt out of subsidizing, say, abortifacient medication. As far as we have seen to this day, this Pandora's box you mentioned has guaranteed the religious liberty of American citizens, not the religious suppression, much like sparing Nebraskan legislators and taxpayers the cost of a direct expression of religion.
Thank you, Counselor. Sure. Mr. Toth, the overwhelming majority, this question is also based on historical precedent, and historically the overwhelming majority of chaplains funded by state governments have been Christian, and they've been from the same very small set of Christian denominations: Episcopalian, Presbyterian, Catholic, Baptist, a few others. Irregardless of historical precedent, if this pattern has existed throughout history and it's a very, very narrow number of Christian denominations, how would you argue this is not violating the Establishment Clause?
Well, in two ways. First, I would say that practice of selecting from specific denominations is not codified. That is the preference of each state legislature and the federal legislature. Secondly, I would ask to examine the effects of that's had on each state and the federal government. Has that had the effect of promoting one religion? Has that had the effect of suppressing other religions? Because ultimately, as we look through history, the establishment of state religion has come to the detriment of religious minorities. And as I've said before, our country has very much been a country of religious plurality. So I think it's hard to say that there is a state religion when we have such a diverse array of faiths.
Thank you, Counselor. I will now allow each counselor to have 5 minutes for rebuttal, and we will start with Mr. Toth.
May it please the court? Thank you. The respondent said that we cannot base this decision on historical precedent alone, but I feel that the respondent has ignored history entirely. A large amount of court jurisprudence has been based on what did the founders intend when they framed the Constitution. And as I've said before, the founding fathers engaged in this practice of court chaplaincy, of state chaplaincy many times. It seems ridiculous to me that they would pen an amendment that would invalidate a practice that they had just quite jubilantly engaged in. And furthermore, if we were to discount their intent entirely, we would have to throw out an entire school of legal jurisprudence. Justice Antonin Scalia was a known believer in looking to the intent of the founding fathers in examining the Constitution. Furthermore, the respondent has suggested that this practice represents a slippery slope, and I question that. The slippery slope is often fallacious. We kind of exaggerate what the effects of such a practice would be, and as I've said before, we have to look at what the effects of this practice have been. Has it suppressed any religion? Has it advanced any religion? And to that I have to say no. Nebraska has not become this unireligious state. There are still quite significant religious minorities within the state of Nebraska, including within the state legislature itself. While they may be uncomfortable with the practice, it's difficult to say if they have had their own consciences suppressed by the practice. Furthermore, the respondent brings up the Lemon test, and they claim that it fails all three prongs of the Lemon test, and to that I have to disagree. They claim that it serves no valid secular purpose, to which I have to say that it does. The creation of a shared culture and a shared set of values is to the benefit of any state, of any society, and I would argue that the prayer does exactly that. The belief in a common creator, be it no matter what particular take on that creator you may have. Secondly, it does not particularly inhibit or advance any religion over another. The fact that it happens to be from a set of denominations is incidental. Thirdly, it does not overly entangle state and religion. In past cases, the court has ruled that entanglement occurs when religion has too much influence over government or government too much influence over religion, particularly with regards to expenses. But in this particular instance, the government is simply making a payment to a religious figure. It's not dictating what he does or does not do with that money. Furthermore, I would ask, should the legislators not pursue the best course of action in their legislative making process? Many people in America are religious and do believe in a creator, and I believe that opening each session with a call for guidance from a higher power is perfectly within their rights, seeking to do the best that they can for both the country and their people. And while it is true that the Founding Fathers are not infallible by any means, we do still have to consider their intent in examining the Constitution today. Thank you.
Thank you, Counselor. Ms. Sarenkoski, 5 minutes for rebuttal.
Thank you, Your Honor. May it please the court. To reiterate, an unbroken history is no grounds for the persistence of unconstitutionality, and I've shown you through judiciary language and judiciary precedent that this does fail all three prongs of the Lemon test, a test that tests constitutionality. A practice arbitrarily determined to be the fabric of our society or to be around for 200 years does not excuse faulty law either. What makes a concept the fabric of our society? How long it's been around? It's the fabric of our society. These slogans and euphemisms mean absolutely nothing. What matters is the law. To reiterate, the hiring of chaplains to open the Nebraska legislature in prayer violates all three prongs of the Lemon Test. Its purpose is not secular, as the opposing side claims. As the dissenting opinion eloquently states, whatever secular functions legislative prayer might play, formally opening the legislative session, getting the members of the body to quiet down, and imbuing them with a sense of seriousness and higher purpose, what may make some people uncomfortable, which the opposing side seems to not care, could so plainly be performed in a purely non-religious fashion that to claim a secular purpose for the prayer is an insult to the perfectly honorable individuals who instituted and continue the practice. To call prayer something that is secular and fulfills a secular purpose is insulting to the authenticity and the sanctity of that prayer. A primary effectiveness in this ritual is non-existent. The Nebraska legislature hosted, through the pockets of American taxpayers, a chaplain of one denomination of one Abrahamic religion for almost 2 decades. To even begin to argue that this does not advance a religion is an insult to the American intelligence. And by advancing the faith of Presbyterianism so incessantly, 16 years, every month they had hearings, the Nebraska legislature is suppressing the input of every other faith, including the faith of no faith. It doesn't matter what tangible effect this practice may have, it's unconstitutional. And for the opposing side to flippantly disregard the discomfort or the suppression of people who have different faiths is un-American. In order to avert the establishment of religion, one truly does have to include the opportunity for all religions and none. As this is clearly not what the Nebraska legislature is doing, in order to avoid violating the First Amendment, the government would have to aggressively entangle itself in every hearing of the legislature. It would have to meticulously keep tabs on how frequently the chaplains were changed, what denominations each chaplain represented once they were changed, as well as how constantly Christianity was the underlying source of the prayers. Just as religion should not be in government, government should not be in religion. This ideal is impossible if you forcefully insert on the citizenry's dime a religiosity only to be challenged and babysat if it is upheld. Putting this much stringency on prayer robs the sacred practice of its authenticity, sanctity, and meaning. It is better to avoid the possibility of demeaning religion entirely, as it could open up doors for religious discrimination, which I would argue it has in the Nebraska legislature. I am not and will not be one to deny that our nation is one full of religion, one which is made better and more charitable by religion. My central premise, though, is that we are undermining the protections Americans have to worship in their own respects or not worship at all if we force religious observance in a public setting. As the public setting is to be filled with figures representative of the people, it is impossible for these figures to truly answer to America's citizens if they officially concede to a religion, in this case Presbyterianism, that neither they nor the citizens they represent categorize themselves by. It not only intrudes upon the private psyches of these representatives, but it also creates an unnecessary and profound divide between citizens and politicians that is incompatible with any state's progress. If I may, I'd like to return to the case of Zorak versus Clausen and Justice Douglas's concerning statements. He admits, we are a religious people whose institutions presuppose a supreme being. We guarantee the freedom to worship as one chooses. We make for as wide a variety of beliefs and creeds as the spiritual needs of man deem necessary. We sponsor an attitude on the part of the government that shows no partiality to any one group and that lets each flourish according to the zeal of its adherents and the appeal of its dogma. The zeal should not be exclusive to those in the Nebraska legislature, and it should not be dominated by a few political elites. The public school, in this case's policy, abided by this judicial warning against competition amongst religious sects and the possibility that one will dominate if not kept in check. The Nebraska legislature has not been kept in check, and the problem we have now is a result of this. Nebraskan politicians are forced to observe the religion of Presbyterianism in order to not cause a trouble as major as a Supreme Court lawsuit, which is happening right now. I and our Constitution is thankful that Mr. Chambers has chosen to speak up for religious liberty. Thank you.
Thank you, Counselor. Ladies and gentlemen, we have heard arguments on both sides of this important question. I now ask that those in the gallery and those participating via simulcast to cast their ballots for which advocate presented the most compelling argument. As you vote, let me reflect on some of the aspects of this case. This question emerged during the arguments from both counselors, who both did a fantastic job, of what did the Founding Fathers intend? In this case, what did they intend as far as the establishment of religion clause goes? Americans have argued about this for generations. Today, a continuing raging debate between Americans exists over what the Founding Fathers intended with the Second Amendment, with aspects of the First Amendment. And as a historian, I can tell you that even the Founding Fathers themselves had the same arguments about the intention and the interpretation of the Constitution. The very first large major political conflict in American history was during George Washington's presidency over the establishment of a national bank under which Alexander Hamilton insisted was constitutional, under which the Secretary of State, Thomas Jefferson, insisted was unconstitutional. It created the first major set of political factions in American history, and it was absolutely based on whether or not the national bank was constitutional, and the people debating it were, of course, themselves Founding Fathers. So we Americans should take comfort in the debate itself, in the richness of the debate, and the fact that this will always exist, the fact that we are so careful in guarding the First Amendment that a Presbyterian minister making a mere $319 a month to issue a very short prayer is worthy of a Supreme Court trial shows us just how seriously we take our First Amendment. So along those lines, I want to thank our two counselors, and I would like to now welcome back our student host, Coco Casey, to announce the results of the vote.
So a big shout out to our student debaters who spent countless hours researching and writing their cases and presenting them for us today. Our audience members listened in attentively and selected Celine Sierenkoski for the most effective case. But we polled the studio audience and learned that before this show, only 60% understood the freedoms associated with the First Amendment. And as a result of participating in this debate, that number moved to 100%. Our campaign is focused on making people aware of their First Amendment rights, and we've been successful too. Join us for our next debate on November 27th at 1:30 at the RMU Academic Media Center.